And the next, no, there you go, Mr. Smoker. The next case is Tampa Port Authority versus Bob Henriquez. This is the property appraiser.
Good morning, Your Honors. Dave Smolker on behalf of Tampa Port Authority. I would note that this particular appeal is traveling together with consolidated appeals in the case that will follow this. And I'd like to reserve 5 minutes for rebuttal.
Sure.
Your Honors, the issue on appeal here is very straightforward. It's whether the property appraiser's 2015 lawsuit is barred by his failure to timely join the port pursuant to section 194.181 sub 2 Florida statutes, which requires that a suit challenging a value adjustment board's grant of an exemption be brought within 30 days of the recertification of the amended ad valorem tax roll. Now, by way of background, I think it's important to understand the mission and authority of the port. It's the governing body of the Hillsborough County Port District. The district is the largest deep water port in Florida, handling almost 33 million tons of cargo per year. Under a special act, the port has the duty to plan for and undertake the development and improvement of the harbor and the shipping facilities of the district. In connection with that duty, they have all powers necessary to carry out the provisions of the special act, and that includes the powers to perform all customary port services and to construct, improve, reconstruct, maintain, operate, and repair any project on land owned by the port district or the authority. Now, projects are defined in the special act to include shipyards, docks, dry docks, and any and all other facilities. The port expressly is authorized also to sell, lease, or otherwise dispose of any property it owns. Now, notably, the special act provides that the port's operations shall be deemed proper governmental functions and that the exercise of the powers conferred by the enabling act constitute the performance of essential government functions. And the types of projects that it's authorized to construct are essentially deemed to be on public property, and they're deemed to be used for governmental purposes so as to qualify them for an exemption from ad valorem taxation under the Constitution and the general laws of the state. Now, the port here entered into a lease with Gulf Marine Corporation, and pursuant to that lease, it authorizes Gulf Marine to operate as shipbuilding and repair and conversion facilities, and to also operate floating dry docks on the parcels and to provide repair and maintenance services to cargo ships while they are docked at the port. Now, the ships that are serviced by Gulf Marine are primarily large cargo ships that carry grain, phosphate, coal, and petroleum. And it is noteworthy that 45% of all of the petroleum coming into the state of Florida arrives at Port Tampa. And under the Jones Act, which is the federal statute regulating such things as oil cargo vessels, those vessels must be maintained and repaired in a US-owned port, such as the district. Now, there's really, I think, two relevant statutes here.
Mr. Smoker, let me ask one question on that particular point. A shipyard, well, let me phrase it this way. A port is clearly a governmental function. Is a repair service a necessary component of that, or that is not a necessary component, but it's still one that the government could choose to provide, and that would make it a governmental purpose?
Well, I think it's actually both. In other words, it is necessary to be able to repair ships at the port, and that is a function that the port could perform. And so it's part and parcel of all powers that the port.
But how does the fact that some large ports do not provide repair services weigh into that? Does that mean it's not essential, but it's optional, or is it still an essential public service?
Well, I think I would answer that question by saying I think it depends on the enabling legislation of that particular port, first of all. And if they have that authority, which the port does here, then it's a question of whether they exercise that discretion or not.
Very good. Thank you.
Okay, but I will point out that this argument or this discussion really kind of goes to the merits of the issue. And Mr. Smoker, your appeal seems to go to more procedural jurisdictional questions, does it not?
This is true, Your Honor, and I'm happy to get there.
Okay.
And I'm happy for you to get there, but this is the Port Authority, and I wanted to
Corral Judge Silverman ever. You know.
I did want to make sure I understood what your client's position is on the underlying merits. And you've addressed it in the brief, but I wanted to make sure I understood that. So thanks.
Yes, and we agree that the port, that the Gulf Marine is entitled to this exemption because they are essentially standing in the shoes of the port.
Right, they're standing in the shoes of the port, and although you guys seem to disagree about how much this constituted a participation in the VAB proceeding, a representative from the port showed up at the VAB, I think at the VAB's invitation really, and said, we're fine with Gulf Marine going forward, you know, and we don't have any objection, basically. So
that's correct. And I think that was the appropriate thing for the port to do under the circumstances given
under the contractual provisions that, you know, in the lease.
Well, and by statute, they are the taxpayer. In other words, they are the owner of the property in whose name it is assessed. And so therefore, the VAB was aware of that and would have.
Right. And so then the port shows up and said, you know, go on without us.
Well, I'm not sure that that's actually factual.
I recognize that might be a loaded characterization, but
I think what they did is essentially delegated the authority to argue for the exemption effectively.
Didn't put on evidence, didn't make an argument, as far as I know, as far as anyone's pointed to, just said, hey, we're here, we know this is happening, we're fine with it.
Correct. I think that's fair.
Mr. Smolker, the Port Authority is liable for the taxes, whether its lessee pays them or not. I mean, you might have a claim against your lessee, but is the Port Authority and its property liable for those taxes to the?
It is, both by statute and case law.
Well, in that regard, can the Port Authority be sued for the money, or can the property be auctioned? You know, can there be a foreclosure of a tax lien on the property?
I think the answer is that it could be sued for the money. The same process that could unfold with regard to anyone who fails to pay taxes.
Well, so could, if I didn't pay the taxes on my home, could the county or the property, the tax collector, I guess, sue me for a personal judgment for the taxes?
What they would do is they would issue a tax certificate. And someone could purchase that tax certificate.
Right, and take the property, but they couldn't come levy on my car.
That's correct, Your Honor. That's correct. Yeah, they would have to follow the same procedure that they would follow in order to recover any delinquent tax.
And an impact on the property ultimately impacts the Port Authority because it's their property.
Correct. And
or
in
really
theory,
property.
In theory, they would have to pay the taxes in order to avoid essentially someone effectively foreclosing on it.
Right.
So getting down to the meat of the issue here, we filed a motion to dismiss after the Port Authority failed to timely join us in the pending lawsuit they had filed against Gulf Marine. They were 3 or 4 months after the 30-day period had expired. And they joined us. They only alleged that, that they didn't even allege that we were the taxpayer. They just joined us. And so we moved to dismiss on the grounds that they had failed to timely join us as an indispensable party pursuant to the statute that governed them timely bringing a suit, which is section 193.1224 and section 194.181 sub 2, which basically says you got to sue the taxpayer within 30 days of the recertification. Now, we moved to dismiss and the trial court denied our motion, entered an order, it didn't have any specific explanation.
Elaborated, right.
That's correct. So our argument is really fairly simple. Strict construction of taxation statutes is required by well-established case law. And that means that the clear, definite limits and boundaries that are established by the legislature through the creation of this tax statute, which is a creature of the legislature, have to be strictly followed. And that means that effectively, when the property appraiser stands before you, he's not standing before you as a favored party like the government normally would. You have to strictly construe the tax statutes in such a way that you indulge in favor, strongly in favor, in fact, under Moss Brothers v. Dickinson, in favor of the taxpayer and against the government. And all ambiguities have to be construed in favor of the taxpayer. Now, the question is, who's the taxpayer? And that's crystal clear. The taxpayer under section 194.181 sub 2 states, in any case brought by the property appraiser pursuant to section 194.0361A, the taxpayer shall be the party defendant. And then section 192.001 establishes the definitions, and it says that the taxpayer shall be the party. I'm sorry, section 192.001 says.
Hard to keep them all the sections straight.
Yeah, Your Honor, it's a challenge, I tell you.
It's like the IRS code, but.
What section 192.001 says is it establishes the definitions which, quote unquote, shall apply to imposition of ad valorem taxes. And then section 192.001 sub 13 goes on to define taxpayer as, quote, the person or other legal entity in whose name the property is assessed.
Well, if we were going to parse that language strictly, is this really a case involving the assessment of taxes or a claimed exemption from tax? Assessment says, the property's worth this much, the millage is this is your assessment, versus we are exempt from all of it. Are they the same things if we're doing a strict construction of the language?
If you're going to do a strict construction in favor of the taxpayer and resolve all ambiguities in favor of the taxpayer, then I think the answer to that question is they're one and the same.
But that's kind of circular, because the question is are you the taxpayer as defined in that strictly construed statute in order to give a construction in your favor? We have to assume that you are, even though we haven't defined that yet. Not a regular circular. Well, because what I'm getting to is the Supreme Court didn't seem to apply a strict definition or apply the definition in that chapter to a chapter 194 proceeding.
That is true, Your Honor.
They acknowledged it. They acknowledged that it was there. They took it into account, but they didn't say that provision is binding. It basically in all litigation involving property taxes.
True. And let me make 2 points. I think when we refer to the property being assessed, it's going to be assessed with a dollar amount. And it's either going to be zero or it's going to be something else.
And the exemption claim here doesn't pay any attention to how much that assessment is, does it? It says, hey, we're exempt from property taxes.
Correct, which means you pay zero. So in other words, there's still an assessment decision that has to be made. And that assessment decision can be either you're exempt or you're not exempt, in which case you're going to pay based on the value that the assessor assigns. But with regard to the case in case, that there was very good reason in that case why the court came down the way it did. And that is that the state was immune from taxation. And so because it was immune, you weren't even dealing with an exemption situation. And the entire rationale of the Supreme Court's decision in Kaysen was that the state's immune. You can't tax them. And if you can't
and yet there was an attempt to assess, correct?
Yes, there was.
Right. And so it would seem to me that would involve an even greater argument that the assessment of the taxes would invoke chapter 192 definition, whereas here it's just a pure claim of exemption. We're not complaining about the amount of the appraisal. We're not anything like that.
Well, yeah, and I think the point in Kaysen though was the court said you can't apply that definition of taxpayer as being
strictly.
the person in whose name the property is assessed if they're not subject to taxation. And so it went to a dictionary
Well,
definition.
they said we have to look at the individual circumstances of the case and decide what the purposes of the statutes are and adjust our definition of the taxpayer accordingly. Not what they said. And then following that line of reasoning, they reached the result that you mentioned.
Well, except I think there's a bright line in Kaysen, which is that the state was immune.
Ultimately, but they didn't just say that.
Yes,
They went through a reasoning process.
Well, true. And I would agree with that. But I think under a strict construction doctrine, you can strictly construe the statute as the court did in Kaysen and arrive at the conclusion that was arrived at in Kaysen because the state was immune. The Port Authority,
even though that wasn't the principle that they were applying.
I think that was the principle that they were applying. That is the rationale, I believe, for that court's decision to not to allow for the state to essentially bring an untimely claim. Was
Mr.
that
Smoker, you and I have used 15 minutes of your time, so you can proceed as you wish.
Okay, I will briefly say that under your decision in the Todora case, I think is controlling. And the Todora case basically said that that definition is plain on its face as to who the taxpayer is. It is not somebody that's obliged by contract. And it's important to note that the legislature amended that particular statute shortly thereafter, and notably did not amend the section that dealt with actions being brought within 30 days by the property appraiser. They did not add that additional language to be someone other than just the owner. It could also be someone who was obligated by contract. And notably, by not making that change, they were essentially agreeing that Todora would apply in this particular instance. Does
it make any difference that they changed the language of the statute from, and they never said shall be the party defendant, they said the taxpayer shall be party defendant, and then recently changed it to a party defendant? Is that a significant statutory change?
Are you talking about the supplementation that was filed?
Yeah, I mean, the laws of Florida that are, certainly some of us found before the supplementation and supplemental authority.
Well, I think the bottom line is that Todora is binding precedent with regard to who the taxpayer is. And it's in this particular instance, it is not somebody who's contractually obligated.
Interpreting a statute that did not say shall be the party defendant, it said shall be party defendant at that time.
Your Honor, I will have
it did. It was not grammatical. The statute was not grammatical. And so we have to figure out what that means. But it said the taxpayer shall be party defendant. What does that mean? I don't know. They've recently amended the statute to say a party defendant.
Correct.
That's the job for us to decide whether that has any impact on our analysis of the case. And I know I'm eating up your rebuttal time.
Yes,
and
Your Honor. So
compensate you.
Let me move real quickly. I think we've elucidated our argument with regard to the timeliness issue. I think strict construction requires that they had to have brought it within 30 days. I'd like to address the relation back doctrine, which I think is in the final analysis, maybe where this case ends up. Although I think, and first of all, there's no precedent applying the relation back doctrine to revive a property appraiser's untimely approval of the reversal of an exemption decision. And that's not surprising, really, because strict construction would seem to stand in the way. And we believe that Rule 1.190C has to yield to the precise command of the 30-day requirement. And moreover,
the relation back doctrine is a court doctrine, is it not? It's not,
it is. And
we're saying cannot be applied where the legislature has said you guys have to be a party defendant and it has to be filed within so many days of the recertification.
I think that's a legitimate argument, but I don't think we have to go there in order for you to reverse the trial court. And the reason is that the law is pretty clear that you can't add a new party.
Well,
after.
does the notion of virtual representation enter into it? Real party and interest enter into those analyses? Because there hasn't really been much discussion of those concepts in the briefs.
Yes, well, again, I think it seems to me that, and I think the law supports this, that because we're dealing with a creature of the legislature gets to control, and the court's normal rules of civil procedure have to yield.
Yeah, yeah, maybe. Is this procedural? Is it, maybe there is Article 5 of the Constitution that says
this is true.
Procedural things are,
Your Honor, you're right.
This case is kind of sticky on a number of bases, and that's one of them. So,
Mr. Smolker, I want to follow up on one part of that. The underlying decision by the Value Adjustment Board, is it your position, and this isn't articulated in, I don't think in the briefs here, is it your position that that decision was binding on the Port Authority, or was the Port Authority necessary in the lawsuit to get a determination whether the property, whoever is now involved in the case, that property is either exempt or not exempt? That was a roundabout question. What I'm trying to figure out is, was your client bound by whatever determination was made by the Value Adjustment Board?
Yes, I think so.
So your view is it's not only a necessary party, but an indispensable party to the later instituted action?
Absolutely, because our rights with regard to payment of taxes were going to be adjudicated in that lawsuit.
For that tax year. For that tax year.
Yes, for that tax year. Correct. So with regard to the relation back doctrine, and then I guess I've used up my time.
Only fair. I'll give you a chance.
Yeah, and Johnson v. Taylor Rental, I think, is controlling. It's a second DCA case, and it basically says you can't add a new party simply because they have a contractual relationship. And here, the only exception appears to be where the interests are identical. And I would submit to you that here the interests are definitely not identical between Gulf Marine and the port. First of all, they're unrelated entities. There is no overlap of ownership. One's a lessor, the other's a lessee. Secondly, the interests are not identical. And that's because Gulf Marine could default on the lease and not pay the taxes. And if that were to happen, then the port would be responsible for the payment of those taxes. And that obligation of Gulf Marine is it's an obligation that could be discharged in bankruptcy. And so where the port finds itself is that if they're ultimately responsible for paying the taxes that are assessed on the land, non-payment could result in imposition of a lien against the property, as distinguished from a lien on the property resulting from the leasehold. You have to look at the property, and in this case, the property would be potentially subject to a lien. And the port's interest here, this is really the bottom line. The port's interest here is in having the taxes paid on the land, come hell or high water. Gulf Marine's interest is in not having to pay the taxes. So their interests are essentially ultimately diametrically opposed. And it's under those circumstances that since the interests are not aligned, you cannot join a new party after that time period has expired.
All right, Mr. Smoker, if you want to preserve some rebuttal time, I'm going to stop you at this point and, offer you like 3 minutes.
I will reserve 3 minutes with the pleasure.
All right. Okay. It's my pleasure.
Thank you.
Mr. Shepard, you're up.
Pleased to court. Will Shepard, General Counsel for the Property Appraiser. Let me first apprise the court of a very, very important point here that I think the Port Authority is essentially misconstrued. In page 12 of their reply brief, so I haven't been able to respond to this yet, and in Mr. Smolker's argument today, they claim that under Florida Statute 197-122 subsection 1, they would be responsible for the taxes. However, that's the wrong statute. There is in no way, shape, or form can the Port Authority ever be responsible for the taxes in this scenario. This was actually pointed out in the Quezon case, where the court talked about the correct statutory provision, and that is Florida Statute 197 432, subsection 10, although in Quezon, I think it was subsection 9, which says a certificate may not be sold on and a lien not created in property owned by any government unit which has been subject to taxation due to the lease of the property to a non-governmental lessee. The delinquent taxes shall be enforced and collected in the manner provided in 196, 199 sub 8. When you go to 196, 199 sub 8, what that says is those taxes would be a lien on any other property that Gulf Marine owns, and the tax collector's resort would be to Gulf Marine. This is actually specifically discussed in the Quezon case on page 314. They talk about this being the case there. When you have a government property that no one's ever going to buy a tax certificate on anything that the Port Authority owns or the state of Florida or the county or the city of Tampa. That's never going to happen under Florida law. They've made sure that that cannot happen. So
even if the property is not exempt from taxation, it is exempt from the enforcement mechanisms that typically apply to ad valorem taxes.
the Port Authority is, that's correct.
That's what I'm saying. That's what I'm saying.
Yeah, and ultimately a property appraiser doesn't get involved in collection. That's obviously the tax.
Well, I understand that,
But they would have to go after Gulf Marine in some way, shape, or form, maybe private action, et cetera. But the Port Authority is never.
you know, I was kind of batting this around in my mind, among all the other things I bat around in my mind. And I'm thinking, okay, why is the Port Authority, given that, even interested? But it's, in the outcome here. But it seems to me that the marketability of the property to a subsequent lessee may well be affected by this exemption, because the exemption remains on the property until the use changes, correct? If there's an exemption, is that correct? As I understand from this, again, from the IRS code, like bevy of statutes we have to deal with.
Yeah, I would say no to that. The statute that claims to have this res judicata effect is strictly on leasehold interest, and this is not a leasehold interest. Because
it seemed to me that provision conflicted with the notion that every tax year is a new dawn.
That's correct. The famous every tax year stands on its own, which has been cited innumerable times.
Right.
So from one year to the next, that's not necessarily, I mean, frankly, we're relitigating an issue that we litigated back in the late 1990s here. So
in this case, yeah, no, I get that.
It can't come up.
If that is the position of the property appraiser, then what is the purpose of joining the Port Authority in the lawsuit?
Well, when it got raised and the court gave me the option, I asked the court for the option just to sort of belt and suspenders myself to put the port in there, but we didn't really think the port was necessary. Gulf Marine ran this action from the get-go with the Port Authority's permission. They're responsible for the taxes by contract. They're responsible under law. They filed the application for exemption. They filed the VAB petition, and they're the party that's going to suffer the consequences one way or the other. And Judge Northcutt, to your position, yes, I think the Port Authority steps in on these actions because it allows them to provide a added benefit to their tenants. But the problem with that under Florida law is that's specifically what the courts have talked about, is you should not give benefit to a tenant just because of the nature of their landlord.
Well, no, what I was theorizing was that this is actually helpful to them if Gulf Marine ever leaves and they want to market this to a future lessee. They can say, and they can't say the property has this exemption until, you're saying that statute that the exemption remains until the use changes, that wouldn't apply. But they were at least able to say our last tenant got this exemption for this activity.
Correct. Sure.
And that might increase the value of the leasehold when they're marketing it to someone else. It's all speculation at this point, but I was trying to say, why does the Port Authority care given the situation?
Right. So look, any definition of taxpayer you look at under Quezon, under the Gulf Gulf Marine's responsible for the taxes under law. They're responsible under contract. They're the party that's been involved with this thing since the get-go. So, you know, you have your other related statutes which talk about lieutenant responsible for the taxes. You have the non-property tax case, the DOR versus Florida Municipal Power. It says the party responsible for taxes for a contract is the right party. So there's almost no way to look at this and say that the Port Authority is maybe anything more than a nominal party that, yes, they probably want to know what's going on with their property, but it doesn't affect them at the end of
That
the day.
seems to support the Port Authority's argument, though, that in fact, it doesn't relate back to the original complaint, that you chose to bring them in for whatever reason. They were not a necessary or indispensable party. And therefore, it doesn't relate back to the original complaint because you're bringing a claim against a brand new party who you just said may not really have any interest in this other than a remote interest.
Well, I don't know that they're a brand new party. I cited a case that talked about the when you have a lease, a lessee or somebody that has an interest in the property, that they are actually a sufficiently related party to bring them
Well,
back.
you know, it's kind of funny because Judge Silverman's question points out that every argument in this case is double-edged, you know, because, you know, does it relate back if they're not proper or indispensable? Well, on the, you know, yeah, no, it doesn't. But they argue that they are, but it doesn't relate back. So, I mean, it's a lot of the analysis here is very circular.
And to the underlying aspect of bringing them in as a party is to make certain, in my view, to make certain that the determination as to whether the property is exempt or is not exempt is binding on them.
Well, I think it's binding when the court makes a decision, because ultimately it's the taxes that we're talking about here.
But it's binding on them because they're the property owner, which seems to me to mean they are a highly interested party, maybe an indispensable party, in order to bind them to the determination as to whether the property is exempt or not.
Except that I don't know why they're highly interested, because they don't pay the taxes and every tax year stands on its own. So what happens in 2014?
Does it bind 2015?
So that goes right to Judge Northcutt's comment of the double-edged sword. If they're
Yeah.
not really interested, then they're not a necessary or indispensable party, and they didn't have to be brought into the suit. And if you wanted to bring them into the suit, then it seems like they needed to be brought in within that time frame under the statute. So I don't want to tell you that's my ultimate conclusion in this, but you know, it seems like we're going round and round as to, well, what is the reason for them to be in the lawsuit? And you're saying, or at least suggesting, it's important that they be bound by the declaration that this property is not exempt to the extent it's being used as a leasehold for another, in the underlying merits, for a for-profit corporation.
Well, we're certainly dealing with the fee simple interest, so that there's an interest there.
Well, yeah, and yeah, but you had, when you filed the amended complaint, you had you survived the motion to dismiss at that point?
It was, no, it was
No,
during the
I don't-
motion to dismiss that I made.
It was
an
during,
tennis-
okay, it's kind
an
of.
tennis motion to say,
Gotcha.
look, Judge, if that's the way you see it, Your Honor, then let me just bring the Port Authority in. They already know about this lawsuit. There's no harm. There's no prejudice to them by bringing them in a few months late. It's a
You
30.
didn't say, you didn't say, oh, you're right, they are indispensable, we need to bring them in. Yeah, I get it.
No, because the statute puts the hook squarely on
Right,
Gulf Marine.
right.
So beyond that, I really think the case-on case addresses it all. It addresses the statutes that say they're responsible. It says you don't necessarily look to 192.011, that subsection. So ultimately, case-on holds the taxpayer is not merely the entity in whose name the property is assessed, but one whom the county has the power to tax, subject to disputes about individual assessments. In short, a taxpayer under section 194.171 is a taxable entity. In this case, it's got to be Gulf Marine, and it can't really be the Port Authority, because they're not going to
Yeah, but I mean, even then, a taxable entity, even though the tax isn't imposed on an entity, it's imposed on the land. I mean, it's, again, we're in a lot of
Yes.
gray, fluffy areas here when we talk
You
about
know,
this.
the statute's not great because it talks about a taxpayer, but at the end of the day, the taxes never go against the individual. It's always,
Technically, the taxpayer, in fact, is the property.
yes,
Correct.
that's correct.
You know,
That's correct.
but that's not how the chapter 192 definition reads it.
Right, right. So when you look to the other related statutes, I think that's what they say. When you look to the objective and purpose of the statute, reliable and predictable method for counties to collect revenue while providing for taxpayer challenges. And when you look at the subsequent years, obviously this is only a 2014 year. In all the other years, Gulf Marine has the ability to sue the property appraiser on their own. And when you look at the real party in interest, how can Gulf Marine be the real party in interest when it's a plaintiff, but not be the real party in interest when it's a defendant? There's some illogical inconsistency there to look at.
When does the legislature ever do that?
Right. So, and the other point is the Primeco case, the Primeco personal communications case really defines this. And I think even the Port Authority defined this as an appeal. For whatever reason, the statutes seem to say when the property appraiser is the plaintiff, it's an appeal, although they clearly say it's not an appeal when the taxpayer raises it. So again, why the
Well,
legislature?
I batted that around a little bit, and I thought, well, I'm not going to raise this because no one else seems to care in the pantheon of case law. But an appeal is a term of art in my mind, which actually then, if it were treated as an appeal, changes, I think, everything in terms of the nature of our review.
It seems strange. It seems strange that there's an appeal and you bring in a completely different party than the party that was.
Arguably, this should be a second-tier cert. I mean, theoretically, judging by the word appeal, and they don't use that word loosely with the other sentence to challenge or review the VAB decision.
So I think at the end of the day, if the port's a party, they're not an indispensable party. That's not where they fall.
Okay.
I really think that
You're saying they are a proper party, but a proper party is not necessary to the resolution of the dispute.
yes, and then we go
And
back.
so when you amended to add them, you added them in your mind as a proper party.
That's correct.
Okay.
And then we get to the rules for civil procedure, which say 1.250C may add a party at any stage of the action, and 1.210, any person at any time may be made a party if that person's present is necessary or proper to a complete determination of the law. And so they were brought, there was no delay here, really. I mean, we filed the complaint, they did an answer, we got to the hearing and we fixed it right away. We didn't, we said, hey, if you want them brought in, we'll do that.
Okay.
I'll reserve any time I have, but I think that.
Well, you don't have a cross appeal, so you don't get to reserve rebuttal. I mean, obviously, you're next up as well, so jot your notes down and look them back over soon. All right. Okay, Mr. Smoker, you're up for a 3-minute rebuttal.
Thank you, Your Honor. First of all, I think there's a difference between taxation of a leasehold interest and taxation of the property. And I read the statutes to essentially say that the inability to impose the lien relates to the leasehold interest as opposed to the taxation of the actual land itself. Now, there is, and we have case law that we've cited in our briefs where the courts have said that the local government, which is analogous to an authority, is responsible for payment of the taxes. The only question really is, what's the process that they have to go through? Do they have to sue Gulf Marine and recover?
The thing is like, and when you say responsible to pay the taxes, that also gives them the authority to pay the taxes.
Yeah,
see, if they have no responsibility, that wouldn't be a proper expenditure of public funds. So when you say they're responsible for those taxes, it could be in that context.
Well, yes.
It doesn't necessarily mean that a lawsuit could be brought and a judgment obtained.
Perhaps. I mean, the bottom line is this, the way I see it is if our client has to sue Gulf Marine in order to recover the money to pay the taxes on the land,
Right.
then that is clearly puts the port in a position where their interests are effectively potentially being prejudiced.
Yeah,
And
the
so-
port was perfectly happy for the lessee to proceed alone at the VAB.
Correct.
Because
Because
going into the VAB, there was an assessment. And correct?
Correct.
And
Yes.
the port was perfectly happy to sit back and let Gulf Marine take care of it.
yes, because I think by the terms of the contract, they're obligated to pay those taxes.
Okay. But if they didn't, you would be in the position that you're describing now as the potential harm.
Yeah, yes, and I think your other point about the marketability is actually a good one. A couple of points I would like to make. One, a larger point. All right. Yes, this is a sort of, we're floating around a little bit of a gray area, but the strict construction rules are supposed to resolve gray areas. And then in this particular instance, they would require that the gray area be resolved in favor of the taxpayer. And in this particular instance, that would require that the property appraiser to have timely joined the property, the port in this lawsuit. And so, you know, the legislature, the other thing is the Casson case is not controlling because it arose under a completely separate statutory provision that was dealing with, and I think the Florida courts, it may be the Merrick case basically says that that particular statutory section has no bearing on a claim arising under the section dealing with the property appraiser bringing an action in circuit court. And so Casson, you know, it sounds on paper like, oh, wow. But if you really analyze Casson, what you figure out is one, it's a different statute that was dealing with a non-claim provision, number one. Number two, the whole rationale for that case was you couldn't be a taxpayer within that definition subject to that time period if you weren't obligated to pay taxes because you were immune. We're not immune.
Mr. Smolker, if we were to reverse on the companion case, does that moot out this case?
On which case?
The case that's
On the
trying
companion case, on the Gulf Marine appellant case.
Oh, I see. If you rule against the companion case.
We were to rule against the port of, against the property appraisal on the underlying merits of the exemption claim. This case goes away, or does it?
Let me see if I don't know that it goes away. I guess it becomes moot, I suppose.
Well, for our purposes of this panel, it goes away. If it's
Yeah,
mooted,
that's
it goes away.
The only other point that I would like to make before I close here is that, you know, there is this other little provision called Section 95.011 Florida statutes that specifically applies to governmental entities. And it says that you have to bring a claim within the time period prescribed elsewhere is the language. And so
Understandable. And I think that, you know, you make, you know, a strong argument that limitation is binding. But the question then is was this suit or appeal or whatever it is properly commenced within that time period even though it didn't add you as a party at the time? I mean, that's kind of where this boils down, I think.
yes, and I think we are an indispensable party. I think
Right, of course.
it's very hard to argue that we're not.
Okay.
So I
So
think in closing, I think if you go down all of the little rivulets and in this particular statutory scheme, I think, and the law, where you end up is, even if this is viewed as a statute of limitations, which I think it probably is fairly viewed that way, the relation back doctrine can't apply because the interests of Gulf Marine and the interests of the port are diametrically opposed.
Okay, thank you very much.
Thank
An interesting case. Spare me interesting cases at this stage of my life, but you know, it is what it is. Mr. Spalker, you will leave our virtual courtroom by clicking leave, I think, but I think there are arrangements have been made for you to hang in on our other side. So I don't know how that's going to come. Maybe you don't want to click that button, and maybe staff can tell me, because you want to kind of hang around in our other virtual
Your Honor,
gallery.
What I can
Judge
do is,
Northcutt,
Mr. Smokler, we're going to transfer you back over to the room. Do not click
So
the
if you
link.
don't click the leave button, just be transferred.
okay. Thank you for your time, sirs.
Sure thing.
Mr.
and you're-
Shepherd, you can click the leave button.
Well, Mr.
Oh,
Shepherd.
no, he's staying. Oh.